Good day, everyone. Now we're going to discuss the case of LITA Enterprises Inc. versus Intermediate Appellate Court, GR number L64693, April 27, 1984. Facts of the case. Sometime in 1966, the spouses Nicasio Ocampo and Francisca Garcia, herein private respondents, purchased an installment from the Delta Motor Sales Corporation 5 Toyota Corona standard cars to be used as taxi cabs. But because they had no franchise to operate taxi cabs, they contracted with petitioner LITA Enterprises Inc. through its representative for the use of the latter's certificate of public convenience in consideration of an initial payment of $1,000 and a monthly rental of $200 per taxi cab unit. To effectuate the agreement, the aforesaid cars were registered in the name of petitioner LITA Enterprises Inc. However, the position remained with tile spouses Ocampo, who operated and maintained the same under the name Acme Taxi, petitioner's trade name. About a year later, one of said taxi cabs driven by their employee, Emeterio Martin, collided with the motorcycle whose driver, Florante Galvez, died from the head injuries sustained therefrom. A criminal case was eventually filed against the driver, Emeterio Martin, while a civil case for damages was instituted by Rosita Sebastian, Viuda de Galvez, heir of the victim, against LITA Enterprises Inc. as registered owner of the taxi cab and was adjudged liable for damages by the CFI. The decision having become final, a writ of execution was issued. 2 of the vehicles of respondent spouses were levied upon and sold at public auction. Thereafter, Nicasio Ocampo decided to register his taxicabs in his name. He requested the manager of petitioner LITA Enterprises Inc. to turn over the registration papers to him, but the latter allegedly refused. Hence, he and his wife filed a complaint for conveyance of motor vehicles with damages. The issue of the case, whether or not petitioner has a cause of action against defendants. Now, for the court's decision. The court held no. Unquestionably, the parties herein operated under an arrangement known as kabit system, whereby a person who has been granted a certificate of convenience allows another person who owns motor vehicles to operate under such a franchise for a fee. A certificate of public convenience is a special privilege conferred by the government. Abuse of this privilege by the grantees thereof cannot be countenanced. The kabit system has been identified as one of the root causes of the prevalence of graft and corruption in the government transportation offices. In the words of Chief Justice Macalintal, this is a pernicious system that cannot be too severely condemned. It constitutes an imposition upon the good faith of the government. Although not outrightly penalized as a criminal offense, the kabit system is invariably recognized as being contrary to public policy and therefore void and inexistent under Article 1409 of the Civil Code. It is a fundamental principle that the court will not aid either party to enforce an illegal contract, but will leave them both where it finds them. Upon this premise, it was flagrant error on the part of both trial and appellate courts to have accorded the parties relief from their predicament. Article 1412 of Civil Code denies them such. Article 1412 provides, if the act in which the unlawful or forbidden cause consists does not constitute a criminal offense, the following rules shall be observed. When the fault is on the part of both contracting parties, neither may recover what he has given by virtue of the contract, or demand the performance of the other's undertaking. Having entered into an illegal contract, neither can seek relief from the courts, and each must bear the consequences of his acts.